All right. Call the order, September 23rd, 2025 Board of Adjustments meeting. Can we all stand up?
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Is there a motion to approve the agenda? Second. Got a second? All in favor, signify by saying aye.
Aye.
Opposed, like sign. Okay. Agenda. Okay, we have one case today on special use. Permit, for 204 North Red Street. I see the owners are here. And I will say for the record, they're my neighbors. I know them, but I don't think there's any problem on my side dealing with this issue if they have a problem. Anybody? Okay. This hearing is a quasi judicial evidentiary hearing. That means that it is similar to a court hearing. State law sets specific procedures and rules concerning how the board must make its decision. These rules are different from the other types of administrative and legislative land use decisions. The board's discretion is limited. The board must base its decision upon competent, relevant, and substantial evidence in the record. It is the decisions constrained by the standards in the ordinance and based on the facts presented. If you will be speaking as a witness, please focus on the facts and standards, not personal preference or opinion. The meeting is open to the public. Parties withstanding have rights to participate fully. Parties are limited to the applicant, the local government, and individuals who can show they have standing and will suffer special damage. Special damages may include parking, stormwater runoff, crime problems, or property value impact. Proximity alone is not enough to prove such. Other individuals may serve as a witness when called. The general witness testimony is limited to the facts, not opinions. Individuals providing expert opinion must be qualified as experts and provide the factual evidence upon which they base their expert opinion. In this hearing, we will first hear from town staff, then from the applicant and its witnesses, and then from opponents to the request. The applicants may choose to reserve time at the end for rebuttal. Parties may cross-examine a witness after the witness testifies when questions are called for. If you want the board to see written evidence such as reports, maps, or exhibits, the witness who is familiar with the evidence should ask that it be introduced during or at the end of his or her testimony. And, everybody deserves a fair hearing. Does anybody have any outside discussion, anything besides what I just talked about, any issues? Okay. Anyone who wants to testify in this matter in opposition with standing should have signed up on the sign-up sheet. If you wish to speak and not signed up, then please sign up now. So that's it. And before we start, we need to recognize the past board member. Her name, Jenna Fontaine, right? She was with us. I don't know if you all know or saw an obituary. Jenna Fontaine, who was a board member when I came on, and I think hardly some of us knew her and served with her. She was an excellent board member, and certainly we consider our condolences to her family. Thank her for her service to the city of South Point. So I thought that was important. Okay. Would I now open the public hearing, Mr. Williams? Or who? You swear to tell the truth, the whole truth, and so. Oh, you got it? I do. Thank you, sir. You are who?
Are you?
Who are you?
Good evening. My name is Wendell. I'm the city planner, case manager for this request. I left my notes back on my desk, but luckily I have my laptop with the notes in them, so just bear with me. Thank you, Mr. Chair, and good evening, board members. For your consideration, I am bringing forth a modification to a special use permit application submitted by Mr. Eric Gibble, applicant, on behalf of Mr. August Adams, the property owner. At the April 22nd, 2025 Board of Adjustment meeting, the applicant and property owner of 204 North Red applied for and was issued a special use permit granting the development of an accessory dwelling units. The SUP granted the property owner permission to develop a detached garage with an ADU building. The approved footprint of the structure was a total of 464 square feet with a 33-foot rear setback and an 8-foot side setback. The subject lot is located at 204 North Red Street, which is approximately 1,800 feet northeast of the Indian Trail Meeting Hall. Zoned as R10, the 0.27 acre lot is adjacent to other R10 single-family residences, as you can see here in that image. And as the UDO's table of uses details, ADUs are permitted, as the UDO's table of uses details, ADUs are permitted in the R10 only by the issuance of a special use permit and only after showing that the applicant meets the specific use standards established in Section 3.6C, as highlighted there. Here's the site plan that was originally brought forth and approved at the April 22nd Board of Adjustment meeting. It is oriented where the left side is 204 North Red Street, and that is, in fact, I want to say south. Here you see that there's an 8.5 side setback between the property line north and the proposed garage, which is highlighted green. The structure is approximately 464 square feet. The footprint of which was 464 square feet. And there's a 33.2 rear setback. This is what also is approved. Gives a little bit more detail. On the right side is the facade. It looks like a barn with the dwelling space going to be above the actual garage portion of the developments. On the left side is a schematic of the floor plan. I would like to draw your attention to the very top of it. That is the stairwell. That's going to come important here momentarily. So what was approved at that meeting was 464 square foot ADU above the detached garage accessible by a stairwell on the outside rear of the structure. However, recently the property owner realized that the design needed an additional 72 square feet of living space. As this addition is approximately 15% more square footage, the increased space would have to be cantilevered outward, which would displace the stairwell. To support the cantilevered portion of the development, 36-inch cube footings would be required, which adds impervious ground coverage. Though the UDO allows staff to make some deviations from board-approved plans, such as special use permits, staff is directed to come back to the issuing board for any deviations that are considered major modifications to those plans. And here I've outlined what some of those major modifications are, but the ones that affect us today are an increase in overall ground coverage by structures, which that's the footings, change in site dimensions by more than 10%, and then a change in access and internal circulation design, which, because they have to relocate the stairwell, that is the change in the access and internal circulation design. This is the applicant's modified proposal. As you can see, it's the same facade. ADU is still going to be up top. What is highlighted red on the back, on the left image, that is going to be the additional 6 foot by 12 foot space cantilevered outward. The setback is reduced from 33 feet to 27 feet approximately. And rather than where the stairwell is going to be, it's going to be in between the house and the ADU off to the rear. Here's a artist rendering of what was being proposed. As you can see, I wish this had a highlight or laser on it. But as you can see, the ladder well is off to the right side of the structure. Thank you. And then those are the footings of the cantilevered 6x12 space. Here we have sections 3.6C of the UDO. These are the specific use standards that are required for an accessory dwelling unit in the R10. The applicant meets all these standards, but I'll go through them real quick. One, the proposed dwelling unit will be detached from principal use or residential structure. Two, the principal use of the lot will still remain a single family dwelling unit. Three, there are no other ADUs on the property. Four, the ADU will be owned by the same person as the primary structure. Five, there is only one driveway on the property that will serve the residents of that primary structure and ADU. Six, parking spaces available on the existing driveway and in the proposed carport. Seven, the original ADU was permitted at 464 square feet. However, with modification request, an additional 72 square feet brings the total to 536 square feet. And then finally, eight, the original garage is detached in less than 530 square feet. Now, this is important to take note of. It's not going to be a case-breaking thing, but we have a provision in the UDO that accessory structures, dwelling or otherwise, if they are 530 square feet or less, they can be as close to as 5 feet from the property line. Well, as this structure went from 464 to 536, they couldn't meet that standard. However, it's a moot point because they still have 27 feet of a setback. So, but I did want to draw your attention to that. In summary, the applicant is asking for a modification to an already existing special use permit that was granted back in April of this past year. They are requesting that this modification allows them to develop 72 additional square feet to their dwelling space. I can answer any questions regarding my presentation or the staff report that you may have, but that concludes my presentation. Thank you.
Thank you, Wendell. Any questions?
Yeah, I guess that.
Yes, sir.
You said with the setback, the side setback is 27 feet. Is that
The side setback is 8 feet. The rear setback is going to be something like 27
the
feet.
rear setback? Okay, and what should that, what are they
8
supposed
foot to the side and 20 feet for the rear is the minimal setbacks.
Okay, so the rear setback is 7 feet larger
Yes.
than what's required.
That's correct.
Any more questions? Do we need to hear?
The site plan show the new location of the staircase?
It did. Can you pop that up?
Because I know the old staircase goes away, I get it. But
Yes,
there's a new one.
the new one's going in between the proposed ADU and the single family residence to the back. Let me
Right, and I'm just curious.
just sort right here. This is the most appropriate drawing of the staircase.
And drawn.
Yeah,
Artist rendition.
You're no room for it.
not to get the weeds, but it isn't cantilever.
Oh,
see it either being cantilever.
oh, I'm sorry. Thank you. I did not know that. I thought it's anytime hanging over.
Not getting weeds.
Thank, no, I appreciate that. That's something I did not know. I thought it was cantilever. I do appreciate that education.
More questions? Anybody feel the need to question the owner about anything?
I don't. Notices all went out. Anything from the neighbors?
Negative, no comments, no, nothing from the neighbors. I did have one phone call just asking what the specifics were, but after I mentioned that, they're like, oh, no problem.
They're here, they'll answer any questions, but
I'm sure after we approve it, you'll get several comments.
I mean,
how it works.
the footprint's not changing and the location of it's not changing. So they're really only reducing their setback on the second level of the structure. So I can't imagine it's gonna be too big of a headache for anyone that's living nearby.
anybody have any questions of the applicant?
Is there anything that has not been brought forward that you think is important for us to hear?
Yes, so.
Straightforward. Yeah, I'm gonna swear them in if I. No.
No.
Okay. All right, well, folks, any more questions? If not, I'll close, the public hearing and, any discussion? With no discussion? Do I have a motion for number one? I didn't swear you in. Is he active tonight? I didn't think we swore him.
We have a forum, so.
When a big moment, we dash.
Okay, do we have a motion?
It will not carry anything to the public health, safety, or human welfare located goes to develop coordinated plan as submitted and approved. Finding fact being, it fits all UDF standards.
Well, second. You got the finding of facts?
Yes, yes.
All in favor, signify by saying aye.
Aye.
Opposed, the same sign. Motion carries. Motion number two.
Use meets all required conditions and specifications. Finding fact similar, there were no all criteria violations. Formed all UDA requirements for the submittal.
Got a second?
Second.
Chris, thank you. All in favor, signify by saying aye. Opposed, same sign. Motion carries. Motion three.
I'll take a whack at it. I'll motion, that, the use, will not adversely affect the use or physical attribute of adjoining or abutting property, or that the end. Finding of fact is that, the additional square footage is only on the second level. And the entrance and is located on the side of the new structure towards the existing residence.
Okay, good. Second. All in favor, signify by saying aye. Aye. Opposed, same sign. Motion four.
Excuse me, Mr. Chairman, who made the second?
Jason,
Thank you.
Yeah, Jason second. Where we at, four?
The location and character of the use developed according to the plan as submitted and approved will be in the area in which it is located and in general conformity with the city Southport Comprehensive Plan. Finding fact, I don't find it that much different than the original plan that we approved. Plus, there's been no objection from any local neighbors or anybody else.
Again. Got a second? Chris, all in favor, signify by saying aye.
Aye.
Opposed, same sign. Okay, that motion carries. And we got a five.
Yes.
Motion five.
Are there any conditions on the last one? There,
Yeah.
the more condition?
Well, no. I mean, are you moving on motion five?
I think that it's standard, that's the boilerplate condition, the rent.
Based on the findings and facts and the evidence presented, the board of adjustment.
I always do the same point we did before.
Yeah.
So, Mr. Allen, will do it again?
Sure. I'll move that based on the finding of facts and evidence presented, the Board of Adjustment recommends approval of the special use application for the accessory dwelling unit, with the condition that it may not be rented. And I'm gonna pause here for a minute. what we had previously said was rented separately from the main structure. Is that is that the exact?
Or you guys want to look at-
I think we had talked about that language one time, make sure that it's still correct. Okay, it may not be rented separately from the main structure.
Right, that's a condition. Got a second here, Jason? All in favor, signify by saying aye. Opposed, like sign. Motion carried. Been approved. You'll get a letter within a few weeks. And thank you. Good luck with the project.
Good luck.
I'll email you tomorrow with
Okay,
a message saying.
Is there anything housekeeping? I know we all get a lot of emails and letters.
Yeah.
You know, pardon?
And then like the fence removal, I've been at, some board order.
Yeah.
I got an updated reg too, and there's peeling. I get one.
Yeah, but.
We're gonna keep the meeting going.
Yeah, of course.
We're live. You're on.
We're talking about 416.
One down there, so.
They're building it.
That's what Rachel did.
I think what I asked is there any housekeeping or any questions that we got? And, you know, we started in on, you know, I guess the emails and I got a letter. And then I, you know, personally, you know, it's what you expect. I think a lot of people were not local residents, a whole lot. So I thought that was interesting. So basically, I've just kind of been reading and letting them go. I think you had a question, Chris, or Rick?
I want to know what the status was on that fence. I didn't ask by Pete.
Yes, so the property owner had 30 days from the day that the order was issued to them to appeal to Superior Court. That date is Thursday, the 25th. Staff has not received anything from them. At that point, then the city can move forward with abatement on our side.
Okay, so we're just going through the process.
Yes, yes.
So it's alive. Okay.
What is the current status of the right-of-way enforcement situation? Is, because I know you said 2 months ago that, 85 citations have been sent out, and most of them have been resolved, and there's still a few that hasn't, and one of them was 416. Is everything still kind of the same way, and is the Board of Aldermen considering any changes or adjustments to the right-of-way policy?
At this point, we have 4 properties that we have sent a second notice of violation to that I believe they just haven't come into compliance and they are fences in the right of way. So I'm making the assumption that they're waiting to see what's happening with the problem. As of right now, I know of no policies or changes from the Board of Aldermen to date.
Good, I'm just curious. I'm sure they're catching a lot.
I'm getting 5 of the email a day.
I got one 3:30 in the morning.
Well, it's a shame that some of the information's not.
It's not-
But you can't worry about it.
Yeah, these people, it's not,
Right.
they don't know.
Right.
They're famous people, so. I don't say anything bad.
You're welcome to forward those emails to staff. I'll be more than happy to answer them and respond appropriately. And the benefit of that is that it's coming from the source and there's no miscommunication. Whereas you may understand 90% of it, but you know what I mean?
I'll forward y'all 88 of them. You may regret asking.
Well, you know, but my response is also, you know, we have periodic openings on this board. And I would just
Feel free to volunteer.
I would like to see some people sit in here to see what the real world's like, so. Pardon?
I'm living from Southport though.
Right.
I'm at 80% of them are from St. James, Long Beach Road, yes.
Well, okay, any other questions about what we're doing with the Harley? I know
I've
you
requested in the past that we get a sheet that has names, how long we've been on the board and when the term is up, so forth. I've back several times. Can you please get that?
Yeah.
So yes, I'm looking into that because some times were changed on there, so I'm trying to locate in the minutes when the exact times are. So that is process.
There's a version, is there a version of it on the website? There used to be more or less. What place?
There used to be, but when we were updating it, we took it down, so.
Gotcha.
Any other? Hopefully, hopefully, that means we'll have it by the next meeting. That's not a problem for people.
Hope not. There's a lot that I'm finding out though, so.
Good night. Is there anything in the pipeline for next month that y'all know of yet?
Another special use permit may pop in. I'm giving them till the end of the week to get their application in. And if so, I'll just be more of the same. For an ADU, should say.
May I make a request if we do, if lawsuit is filed by the owners of 416 Bay Street, if you could you just let us know? Is that, you know, just.
Anything else? I'll entertain a motion to adjourn.
So good.
Second.
All in favor, signify by saying aye. Aye. All opposed. We're done. Thank you.